And you know, that is a perfect starting point for me. And I'll be giving you reasons why we should not admit this charge. You know, this charge is drawn, and it is alleged that the person before you has done something contrary to section 84, subsection 1 of the Penal Code. And you know, that is the section which I've opened. That section, and if I may just read the words that are in the charge sheet, that Jayne Kihara on 8th day of July 2025 at Nairobi City within Nairobi County, being in a public gathering, uttered the words to it. Now the words are there, the paragraph is there. It concludes, with intent to provoke breach of peace. So, I submit that that charge, as drafted, does not disclose any offense under section 94, subsection 1 of the Penal Code. These are the reasons you know. That section reads, a person who in a public place or a public gathering uses threatening, that's one, abusing, that's the second one, or insulting words or behavior. So, the operative words here are, those words must either be threatening, there's no suggestion that she used any threatening words, abusive, it is not alleged she used abusive words, or insulting words or behavior, it is not suggested that she used any insulting words. And then that is when an offense is constituted. So the charge that is before you does not have threatening, abusive, or insulting words or even behavior that would go on and cause breach of peace and all that. So basically, the offense that is before you is horrible. The other part of the section is just saying how minor that offense is just a fine of 5,000 shillings.
Can you address the other element?
Yes, I'm coming to that. I just caught my eye with the fine, which is 5,000 shillings. So, then, with threatening, abusive, or insulting words or behavior, there's no suggestion that has taken place, with the intent, one, to provoke breach of peace. That is the one that has been taken. So that for you to have an offense where the intent is to provoke breach of peace, those words or that conduct must fall within the 3 parameters, or any of the 3 parameters that I mentioned. What is before you does not fall under any. Under subsection 2, the Act then defines what is a public gathering. And what you will find is that one situation where there is a gathering is when there is any meeting. So basically, when a charge reads a public gathering, a prosecutor must take the charge to what kind of a gathering. Is it a meeting? Under paragraph A. Gathering or concourse of 10 or more persons in any public space. So you're not being told, were they 2 people? Were they 1? Were they 3? Because the minimum number is 10 or more. And it must also be in a public place. This charge does not say the public place or any place. We are just being told in Nairobi. All of us in Nairobi. Yeah, even here is in Nairobi. So, which is the public place? So, that way, the offense is not disclosed. Paragraph B. Any meeting or gathering which the public or any section of the public of more than 50 persons are permitted to attend or do attend, whether on payment or otherwise. There is no suggestion, it has not been indicated whether there were 50 people, whether these people paid to be there, they didn't pay to be there. So what is Honorable Jayne Kihara supposed to defend? These particulars are not in the charge. And finally, the other situation is the paragraph C. Any procession in, to, or from a public place. Any procession moving in or out of a public place. We are not told that these words were uttered in those situations. You know, when a charge is brought before you, under section 94, sorry, under section 134 of the CPC, one thing that should stand out is the following: that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving a reasonable information as to the nature of the offense charged. The information that is contained in this charge, Your Honor, is insufficient under subsection 1. It is insufficient under subsection 2 of section 94 of the Penal Code. Would it be right then if I shift to that point? You know, when a charge, and the section which I just referred to, that is section 134, is indeed the section that implements the provisions of Article 50, sub-Article 2, paragraph B of the Constitution, that provides that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. The charge that is before you does not have sufficient details as defined in the implementive statute. So if she goes ahead and pleads to the judge as brought before you, it will be a violation of Article 50, so Article 2, paragraph And important to mention, Your Honor, that under Article 25 of the Constitution, and for emphasis, I want to read what it says. That despite any other provision in this Constitution, the following rights and freedoms shall not be limited. These are rights which cannot be limited. And one of such is the right to fair trial. That is paragraph C of Article 25. The right to fair trial is the one that I had talked about under Article 50. So you are then placed in a position where you have a charge that is in contravention of Article 50, and you're being asked to allow a person to plead to those charges. Your Honor, decline that invitation. And Your Honor, I do not want to talk much because before we came here, we were before you again in another matter with the same prosecution team and Mr. Mageto for Honorable Bure. And yesterday we slept very late because we were at the DCA headquarters to deal with an issue of Honorable Bure. And now we went to the other day, then yesterday we were dealing with Jayne. And no, so that Your Honor, I do not want to tire you because we're also very stretched. But the context of that is that there is a pattern, and this court should rise to the occasion and see what is happening and uphold the Constitution. And that will be done. And I invite my friend, our chairman, Mr. Mbogo Wanjohi, to make something.
No, that is not the introduction they give to our chairman. This is our chairman of Gema Wado, which is an organization of about 6,000 lawyers. So you cannot just give that introduction to this.
Thank you. Well, it's enough to do. You're the chair.
We have an association which has about 8,000 lawyers practicing in Kenya, others in Kenya. It's called Gema Wado Association. Very many lawyers.
What he is not telling you is that he has now incorporated our cousins from Mount Kenya South.
Guys, our Thank you. For that introduction.